Good morning, everybody. Great to have you here for another installment of the Fletcher, Hildreth webinar series. This morning's topic is going to be controversial advertising and also general sponsorship identification issues, which are always very important for broadcasters across the country. With me is my usual partner in crime, Dan Kirkpatrick. I'm Frank Montero, and given the fact that we're going to be covering among our topics marijuana advertising, we were wondering whether we should just refer ourselves as the Cheech and Chong of the FCC communications bar. But I want to thank the Colorado Broadcasters Association for helping to set this up, and also to Justin Sasso, the head of the CEO of the Colorado Broadcasters, for proposing this as an idea for a webinar topic, which I think is a good one because we've actually learned a lot as we've been preparing for it ourselves. Also, for those of you who are new to this series, I want to invite you to check our blog, our comlawblog.com. You'll see reference to that on the upper right corner. It's a blog that our firm puts out to all subscribers. It's free. It gives updates on a wide variety of FCC, intellectual property, and telecommunications law-related issues, and many of our clients and friends of the firm find it very informative. Likewise, for those of you who are members of the Colorado Broadcasters Association, you no doubt are aware that we put out a memo to the members of the Colorado Broadcasters, which is distributed out front by Justin and his team to the members, and that likewise tracks a lot of the issues that we cover in the blog on a wide variety of FCC-related topics. So this morning, we've got a lot of ground to cover here. And as you can see, our topics are going to be in order: marijuana advertising. We're going to do a little refresher on tobacco advertising, but an interesting sidebar on that one that has developed is e-cigarettes and vaping, which has created a lot of controversy and how those can be handled on advertising. Refresher on alcohol advertising. We're also going to touch on false and misleading claims in advertising, and then move on to casino gambling, sports gambling, which is recently, because of a Supreme Court decision that we'll be discussing later on, has become a white hot topic among media companies and broadcasting companies, and at the state's level of how those can be handled. And then we'll be moving on with state-sponsored contests, and then a general refresher on sponsorship identification. And as usual, Dan and I will be engaging in our banter, and I'm sure we'll be covering a wide variety of other topics as well. Before we move on, I will also want to point out that, as usual, you'll all have the opportunity to ask questions if you so desire. I believe, depending on how your screen is set up, on the right-hand side of your screen, you'll have an opportunity there to type in a question and submit it in. And at points during our presentation, but especially at the end, we hope to field some of those questions and be able to give answers to those as they come in. Today's webinar is going to last approximately an hour, including the Q&A period. We may run, a little under, a little over, but in fact, figure that it's going to be approximately an hour, which means it's 11 o'clock here in Washington, D.C. For those of you tuning in from Colorado, we should be done by about 10 o'clock your time. So, so with that, I'm going to turn it over to my colleague, Dan Kirkpatrick, to kick us off on a hot topic these days, namely marijuana advertising.
Thank you, Frank. Thank you for not bogarting the full webinar this morning. That said, I will try to not make too many bad puns. I will choose to take the high road, as they say. In any event, marijuana advertising, has certainly become a very big issue over the last few years, with states moving to legalize both medicinal and recreational marijuana use. There's clearly a very large market and a lot of money involved in advertising those businesses. Unfortunately for broadcasters, sale and use of marijuana is still prohibited on the federal level. You can see here we have the language from the Controlled Substances Act, which says, in addition to the sale and use being prohibited, it says that you cannot use any communication facility in facilitating the commission of any acts that are prohibited under the act. And obviously, the sale, use, and distribution of marijuana is an act that is prohibited under the Controlled Substances Act. So, using a communication facility like a broadcast station to facilitate and advertise those services and products is prohibited. This may be a felony in and of itself, using your broadcast facilities to advertise the sale of marijuana. And this is problematic not only by itself, but also because it can jeopardize a station's license entirely, in that there are character qualifications that the FCC imposes on licensees, and a felony conviction is something that can jeopardize the ability to hold a license. Obviously, for the licensee, that is critical, and for any station employees, that is also critical, in that you do not want to be the person who jeopardizes the license of the station owner. Federal enforcement, the DOJ, the Department of Justice, is the federal agency that is tasked with enforcing federal drug laws and those against marijuana. So far, the DOJ has been generally hands-off in taking enforcement actions in states where marijuana is legal. They are focused more on trying to target those businesses that cause other issues. That, as you can see this list here, which I will say, this is taken from some DOJ guidance and an informal memo that came out under the Obama administration. So obviously, sort of where this stands now, it was informal advice to begin with, and with the change in administrations, you can't really rely on this as a legal matter. But this is, certainly if you are violating these things, then you're definitely going to subject yourself potentially to prosecution from DOJ. But the things they're looking at are things like, if the businesses are distributing to minors, or if they are funneling revenue to gangs or criminal enterprises, if it's a business that's distributing to a state where marijuana use is not legal, if there's any sort of violence or other illegal acts that are coming out of the marijuana business, if they're growing on public lands, things like that. Those are the things that the the DOJ is going to look at in deciding whether to prosecute a marijuana business. And on top of that, where they're going to look to prosecute, if you are advertising a marijuana business that does any of these things, you could be subject to prosecution as well.
So Dan, basically what you're saying is that although there is nothing concrete on this, that it sounds like the Justice Department has largely been taking a light touch on this, unless they engage in one of those activities you mentioned, in which case that's kind of a bridge too far for them. If you're targeting minors, if there are gangs and drug, gun running involved, then they're like, whoa, now that's too much.
That's right.
We're not going to, then they're going to step in.
Right, exactly. It's not, if a marijuana business is licensed by the state and is complying with that license and is not violating any other laws, the DOJ is probably not going to crack down on them. But if they're doing anything else illegal, that's when there's really going to be a problem. The FCC has not been involved in cracking down or regulating marijuana advertising as of yet. High-level FCC staff, however, have said that broadcasters really should not be accepting any marijuana advertising, and they highly recommend against it. If you do as a broadcaster, obviously there is a risk, a cost-benefit analysis here. There's potentially a lot of money involved. Maybe for some broadcasters that outweighs the risk. If a broadcaster does make that decision to accept marijuana advertising, at the very least, they should use a lot of diligence to ensure that that client is not engaged in any of the violations we talked about on the previous slide, that they're not selling to minors, they're not advertising to minors, and that they're properly licensed in the state. If you want to check and make sure if you get a request for ad time from a marijuana business that it actually does have a state license and is in good standing. I'll also just reiterate that this federal enforcement policy to not go after law-abiding licensed marijuana dispensaries or distribution centers, that is subject to change at any time. There is nothing binding about that current advice, and the DOJ could change its approach. Obviously, we have a new attorney general who is in confirmation hearings now. He could change the policy, although he did say in his confirmation hearings the other day that he did not intend to. It was not going to be a priority or a focus of the DOJ to go after otherwise legal marijuana sale and distribution.
I want to jump in here for a second because this is this last slide that we had was covered a very, very important topic, which is an issue that comes up with us all the time, which is broadcasters calling us, or they're calling Justin at the CBA offices. You're increasingly hearing it in other states that have legalized marijuana, where broadcasters say, "What do I do? Can I take this advertising or not?" Because there's these dispensaries are spending a lot of advertising dollars with newspapers, billboards, and why can't we participate in this commerce that's becoming a bigger part of our state's economy? And what we have told our clients, and what I believe the CBA has told their members as well, is the following: as broadcasters, you have a federal license to engage in the broadcasting activities that you have. That's something that makes your situation very, very different from, say, a billboard company or a newspaper company. That federal license means that you are under scrutiny by the federal government. And remember, this is a federal law that makes the advertising and the engaging of activity that will facilitate the distribution of marijuana. It's a federal law that makes that illegal, not the state law. So, what we've told our clients repeatedly is, look, it may be, if it's legal in your state, fine, but you have to be extremely cautious, and we would urge you to not run these advertisements because it remains illegal on a federal level. You have a federal license, and you have vulnerability there. I know it's very, very hard when your competition and newspapers are taking these dollars. But again, exactly as Dan pointed out, and has been pointed out to us by the CBA, in meetings that state broadcasters, including the CBA, have had with very high level FCC officials, they've basically said, we would recommend that you not take this advertising at this time, even though both the Justice Department and the FCC have, basically taken a hands-off policy on this. So that's where we are on it.
Right, and I would add that it's possible that this may change, could change in your favor. There has been some legislation introduced even in the new Congress that would basically decriminalize on the federal level a lot of this, sort of state authorized sale and distribution of marijuana. And if that happens, then you would be free to take these ads, depending obviously on the exact terms of what is adopted by Congress. But I wouldn't get my hopes up too much for that at this point. Congress has sort of larger priorities that it has to deal with at the moment, and may or may not get to this at all. In addition to DOJ and FCC, there are other federal agencies that are involved in that may touch on marijuana advertising. One is the Federal Trade Commission. They have not to this point been highly involved. They don't generally get involved in whether a product that is being advertised is legal, but more in the truthfulness of the advertising. And where this can really come up is if you are taking ads, or if there are ads that make claims as to the medical benefits of marijuana. If those claims are either false or simply unsupported, you could be subject to FTC regulation and enforcement actions there. We'll talk a little bit more later on about sort of general FTC enforcement of false advertising, but it can clearly come up in marijuana advertising when it comes to medical benefits and things like that. Also worth noting is that there are IRS and Treasury regulations that apply to banks and restrict how they can do business with marijuana distributors. The effect this has had is that it has forced a large portion of the marijuana business to be conducted almost exclusively on a cash basis. That would also apply to these businesses coming to you to try and make an ad buy. They are probably going to be asking to do that in cash. And if you make the decision to accept the advertising, that is something just to consider and see what whether that is something you want to do or what the implications of that are. As we said, state laws, even in those states such as Colorado that allow marijuana use and distribution, those laws may also apply to there may be additional laws that apply to advertising. In Colorado, they've said that marijuana advertising is only allowed where the advertiser has reliable evidence that no more than 30% of the audience is expected to be under 21 years old. Again, sort of a mirror of what is in the federal enforcement, although this one has, is explicit and specific and has the power of law. But they're trying to avoid any advertising that is targeted towards children. Generally, these laws target the advertiser, and they don't explicitly say anything about a broadcast station taking the advertising, but certainly it could be used to go after a broadcaster if they are accepting advertising that does not itself comply with this law. You would lose the ability to say, look, we were just taking advertising for a legal product that was done legally. That's not going to be the case. You would be taking advertising that was not legal if it did not meet these standards. Again, just to reiterate that there is the potential for this whole regime to change significantly at any time. It could come from the state, the DOJ, the Federal Trade Commission. States, obviously, Colorado and many other states are pushing more towards greater legalization. But with the change in administration, at least from the Obama administration to the Trump administration, it's likely that the DOJ is less likely to look favorably on the marijuana industry. That was really true under the Jeff Sessions DOJ, who had he had a long-standing and explicit opposition to marijuana. It's not likely that if Bill Barr is confirmed that he is going to have quite that same outlook, but we just don't know where that's going to go. I will say it's unlikely that the FCC is going to be the one leading the charge on this. Really, they're probably going to allow other agencies to take the lead. And if DOJ, the FTC decides to crack down on this kind of advertising, then the FCC is probably going to follow their lead on that. So we'll move now from marijuana advertising to tobacco advertising. I will turn it over to Frank to talk a little bit about that.
Let me pick up there. I'm talking a little bit about the legal weed, or at least the traditionally legal weed that is also as most of you, all of you should know, is significantly regulated in terms of the way it can be advertised. For most of you, this is probably just going to be a refresher, but it warrants a revisiting of what the law says on these matters with regard to tobacco advertising. Congress long ago banned all ads for cigarettes, what they call little cigars, smokeless and chewing tobacco, and this applies to any medium of communication under the FCC's jurisdiction. So, you know, we're talking about radio, TV, low power stations, you know, on any variety of matters, satellite radio as well. It applies. When considering exactly what type of a product is covered here, the FCC looks at any roll of tobacco, whether it's wrapped in paper or in some other substance that does not contain tobacco, or whether it's rolled in a substance that does contain tobacco, that is similar to a traditional cigarette. This is a criminal statute, and a violation is a misdemeanor, and it is punishable by a fine. Where things get a little dicey sometimes, and where we get a lot of questions, are with sort of ancillary businesses that also want to advertise on broadcasting. A good example of this are you know, traditional smoke tobacco shops. We have plenty of them here in Washington, D.C. And they may want to advertise on your station, and the question is frequently come up whether that's permissible. And the answer is yes, it is permissible within certain guidelines. So, for example, if the store that wants to advertise happens to have the word tobacco in its title, you know, Joe's Tobacco Shop, for example, that's okay for them to advertise on your station, as long as they sell legal tobacco products that can be advertised, and you know, provided that those guidelines are met, then you can run that ad. What the Justice Department, the DOJ, has cautioned, though, is if you have a shop that uses not the word tobacco, but the word cigarette in its name. So now, instead of talking about Joe's Tobacco Shop, we're talking about Joe's Cigarette Shop. They've basically given an opinion that those sorts of ads should be avoided because it basically can rise to the level of advertising cigarettes as a product. Another sort of...
Can I just jump in for a second? One other thing to look at and be careful for there is even a legal tobacco shop, and this really applies to television stations more than radio stations, but if you have a station that, or an advertisement for a tobacco shop that shows, say, a picture of the building, if there is a large and prominent ad for cigarettes in the window of the store, that could get you into trouble. You know, you have to look not only at the store itself and what it sells, but the content of the specific ad that they're asking to place to make sure that it does not, in fact, look like a cigarette advertisement.
That's a very, very good point. Absolutely. So the visual here, you know, is very important. And if you're uncertain, you know, we urge you to contact the CBA, or if you're not in Colorado, contact your state broadcast association, or contact your FCC counsel to get a reading on the particulars of that particular ad and whether you know, it should be run or not. Another ancillary business that may want to advertise has been traditionally, you don't see this as much as you used to once upon a time, but there used to be frequently sporting events, for example, that were sponsored by tobacco or cigarette companies, and those companies got naming rights on those events. You know, probably the best known ones traditionally were the Virginia Slims tennis tournament. You had the Winston Cup, for example, in NASCAR, and the question came up whether those could be advertised. And the guidelines that have been provided are that they can, provided that the following guidelines are met. Number one, that the event actually exists, and it probably sounds like that's some kind of a bizarre requirement, but the concern that's trying to be addressed there is that there have been in the past sort of events that were sort of created that were bogus, that were sham events that were set up purely as a sort of a backdoor way to get a cigarette promotion out on the air. So you want to make sure that it is in fact an event that exists. That the name of the product, the cigarette, the tobacco product, is in fact a legally registered part of the name. So Virginia Slims tennis tournament, that's good. The Colorado tennis tournament brought to you by Virginia Slims, not good, because now it's not actually part of the name. So you want to make sure that it's actually part of the legally registered name of the event. And then last but not least, you want to temper the degree to which the name of the event with that tobacco cigarette product's name in it is mentioned on the air. You don't want to have it be mentioned in every sentence. It's entirely possible that the promoter wants it mentioned all the time, but just use a certain degree of reason when you look at the frequency with which the name, the cigarette product, the tobacco product, is mentioned on the air. To revisit another traditional issue here is there's a new twist on an old theme is the idea of e-cigarettes and vaping. That is completely turned the traditional notions of what can and cannot be done with regard to tobacco and cigarette advertising a bit on its head. Obviously, e-cigarettes and vaping usually do not involve tobacco products, but nonetheless are this delivery system for the intake of nicotine. As it stands right now, ads for e-cigarettes and for vaping are not banned and can be taken, but the Food and Drug Administration, the FDA, has been drilling down into these products with greater specificity and imposing restrictions and regulations on them. And probably to start, they are now already requiring that there be a disclosure on the air in any ad that points out that e-cigarettes do in fact contain nicotine, and that nicotine is an addictive chemical. They are also, the FDA are prohibiting claims, which were sort of a very traditional marketing slogan by e-cigarettes and vaping companies, that they were healthier than cigarettes, a good, healthy alternative to cigarettes. The FDA is saying no, that those claims will not be acceptable anymore in advertising. Or alternatively, that e-cigarettes or vaping can be a methodology for quitting cigarettes. They don't want that included in ads anymore either. And then most notably, the FDA is really cracking down on the marketing of these products to children and ads that target minors and children. And this especially you want to look for ads that have the cartoon characters, the bright colors that look like they're going after teens, make it using teens in their ads that make it seem like it's cool, it's fun for minors to use these products. The FDA is really starting to crack down on these. So
just to add one thing that one sort of specific thing that they look at there frequently is if there is any kind of sort of logo or cartoon mascot or anything like that involved, they're almost certainly going to think that that is designed to target children, sort of like the old Joe Camel ads.
Yeah, that's a really
that got Camel into so much trouble. And it may be that maybe the shop has a logo in its name that potentially could look like it's trying to target children. So you just want to be very careful, very careful with that.
Yeah, I mean, and that's I think what Dan says there pretty well sums it up, just on a big picture level, which is that e-cigarette and vaping ads are currently permissible, but approach with caution because there are restrictions. The government, specifically the FDA, is starting to look at these with a greater regulatory eye, and this is especially true if you have a large percentage of you believe to have a large percentage of minors in your audience, underage viewers or listeners, depending on your format. Just be very, very careful when taking on these ads. So now I'm going to turn it over to Dan, who's going to look at another oldie but goodie, which is alcohol advertising.
Yes, back to another category of vice. This one is actually somewhat more straightforward, really, than the others. It's been around a long time. There are no federal restrictions on alcohol advertising. There's nothing in the federal law. And part of the reason for that is that the alcohol industry and the advertising industry have adopted these voluntary standards and guidelines restricting where alcohol ads are placed. Essentially, again, as with many of these other things, it's designed to avoid putting them in front of children. The guidelines say that alcohol ads should only be placed where more than 70% of the audience is expected to be of legal age. This may look familiar from the marijuana restrictions that had the 30% there as well, and that's where the marijuana laws probably took this, was looking at the standards for alcohol. So you can accept alcohol ads, you just need to be careful of where they are running. And that's particularly important, if you're accepting ads that are scheduled for something like a run of schedule or something like that, making sure that they don't get into programs that may have a substantial number of children and children under 21 here, particularly in the audience. In Colorado, there is a particular, a specific law that says that you cannot advertise a greater or lesser alcohol content than actually is in the beverages. That one is still there. I think this is really something of a holdover from the old near beer laws in Colorado that were repealed at the beginning of this year. But it also applies, again, this sort of standard of truth in advertising that we've talked about a couple of times, and we'll again talk about later. That if an advertisement is saying something that isn't true, that's going to get you into trouble, more often than anything else. But again, here, you just be careful. The NAB and the CBA, they actually help enforce this, these standard guidelines. It's very important for the industry to avoid having federal restrictions placed on them to comply with these guidelines. And that's part of the reason there haven't been laws, is that the industry does a really good job of this.
That's right. I mean, I think Dan nailed it, which is that the voluntary standards for alcohol, and I think you may, see this on other products like vaping and e-cigarettes, are aggressively enforced because the industry wants to, prevent a situation where the the legislature feels that the industry is not properly policing itself and that therefore needs to enact statutes or guidelines itself. So keep those in mind. The next topic that we're going to be jumping into here now is false or misleading material in advertising. The FCC advises that that broadcasters, when taking all types of ads, have to be conscious of the fact that they, bear a responsibility to their audience in terms of the content of the ads that goes out. And what that means is that they have to, exercise a reasonable degree of care to make sure that the ads are not false or not misleading. So if you see an ad or somebody's trying to promote an ad to you to buy a spot for a product, and there's word going around, I've had this come up with clients, word going around town that these guys are throwing a lot of money around for advertising and whatever it has, timeshares or weight loss products or your snake oil salesman, and that there's reason to believe that it's bogus or that ripping people off or whatever. Think twice before taking those ads, because you do have a certain degree of responsibility. The FCC, when judging these ads, largely will throw the responsibility for the complaint and the adjudication of these misleading and false ads over to the Federal Trade Commission. And in fact, the FCC even has a link on their website where they send people over to the FTC towards the procedures there to file complaints. But don't lose sight of the fact that although the FTC is going to be fielding complaints against the advertisers, the actual vendors of whatever that product or may be, that nonetheless you as a broadcaster don't want to be scrutinized by the FCC as having knowingly put on the air advertisements for products that were fraudulent or that were misleading. Another category of misleading or false material is hoaxes. This can come up a lot in terms of April Fool's jokes that may be put on the air. Probably everybody knows that the most famous one, of course, was the War of the Worlds broadcast. But these hoaxes, these practical joke kind of content can work their way into advertising as well. And so you have to be careful when you're putting this material on the air, both in terms of anything that the station may be doing or that advertisers may be doing. And what the FCC basically spells out is a test for determining, when information or content should not be aired. So the FCC generally prohibits broadcasting information regarding a crime or a catastrophe if the following: one, that the broadcaster knows that the information is false. Two, that it's foreseeable that there could be public harm from the trickery or the practical joke that is put on the air. And finally, number three, that there is in fact a harm that is caused as a result of the broadcast. If those three elements come to pass, then the broadcaster can be facing a fine or forfeiture at the hands of the FCC. One way around that is to air a disclaimer in the program that's being put on, so that you make it clear to the listener or to the viewer that in fact this is a hoax, that this is a practical joke, not to be taken seriously, and that if you do put on a disclaimer, then basically the foreseeability of the harm is addressed. And so when you put on the disclaimer, you want to make sure that it clearly characterizes the program as being fictitious. And also that you put on the disclaimer in a way so that it's reasonable that the viewers or the listeners will actually see that disclaimer and become aware of it.
But one thing I would add there is that, on disclaimers, what is reasonable depends on the program. If it is something like a hour-long program, it's probably not reasonable to just put a disclaimer at the very beginning. You probably have to put them on some of the ad breaks in the middle of a program.
Right.
If it's a 30-second, 1-minute ad, then yes, putting it right at the beginning is probably enough. One other thing I would just say, it's not on our slides anywhere, but one thing that a disclaimer will not protect you from at all is if there is an advertisement or a show that includes false EAS tones. This is something the FCC has cracked down on a lot in the last few years. Those tones that show up at the beginning of an EAS message cannot show up anywhere else other than a genuine EAS message. There have been some very steep fines. I can't remember the name of the movie, but there was a movie that advertised using the Minutes advertisements, and a lot of stations got in trouble for broadcasting those ads. So if you get any advertisement, anything that includes those, do not air it.
Right. Is it also true, Dan, that in fact, like in the classic War of the Worlds, there was a disclaimer, but it was put on in such a way so that it was difficult for the viewer?
Yeah, that's right. It actually was. In the War of the Worlds, they put a disclaimer at the beginning, but apparently at the time, in the world of 3 broadcast radio networks, very few people were listening at the beginning, and a huge portion of the audience tuned in, 5 or 10 minutes in, and never heard the disclaimer, and all they heard was the actual programming. So that led to some bit of panic, and that disclaimer just didn't get to people, and you have to sort of take that kind of thing into account in programming your disclaimers.
Right. So to close on the issue of false misleading material, while this isn't it isn't a rule, it isn't mandatory, we just think it's generally good practice if you could seriously consider, if you haven't done already, developing some written guidelines for your announcers, for your on-air folks, regarding these issues, which would prohibit the deliberate broadcast of false or misleading or deceptive material, so that you can show that in fact the station does have a best practices in this area to safeguard against it happening again. And so with that, I'm going to now throw over to Dan to our next topic, which is going to be casino gambling and lotteries.
Yes, casino gambling. This is something that the advertising of casino gambling is something that was much more controversial, say 10 years ago. It has sort of, after some court decisions and sort of the increase in casino gambling in many states, it has become really understood broadly that if a casino is operating legally and is authorized by state law in the place where it is operating, that it can advertise, and you as the broadcast station can take that advertising. In Colorado, the law says that casinos can be advertised as long as the activity is legal where it's conducted. The Colorado Department of Revenue regulates casino gambling in the state, at least outside of Native American tribal lands, and has authorized these 3 communities you see here to operate casinos. So if you are approached with a casino advertisement for a casino that is not located in these areas, that could be problematic. If you have, and it doesn't necessarily have to be just casino gambling, but really gambling more broadly. If you have a bar that wants to advertise that it has poker games, that's going to be a problem. Or it has, video slot machines. That's going to be a problem if they are not legally authorized to do those things or to have that kind of gambling. As we said, there's an exception to both state and federal law allowing Native American tribes to operate casinos on their tribal lands. And in places where that is happening, those casinos, again, as long as they are operating legally, they can advertise, and you as a broadcaster can take that advertising. In addition to casino gambling, another variety of gambling that may, occasionally want to purchase advertising is lotteries. The three elements that define something as a lottery are a prize, so there's something you can win; chance, in that the prize is, there's at least a large element of chance in terms of who wins the prize. If it's a game of skill, then it will not count as a lottery, but if it is, largely chance, it does. And consideration, and the person who ultimately wins has to have either paid something or done something to become eligible to win. A promotion that has all three of these elements and that is not exempt under the law should not be conducted and certainly should not be advertised.
Yeah, keep those three elements in mind. Put a pin there, because they're going to come up again when we discuss contests as well.
Right. The first category of lottery that is almost always able to be advertised is state-sponsored lotteries. Most states have these, and obviously the states have decided that for lotteries that they are conducting, they should be able to advertise them. So you can advertise a state-sponsored lottery both in the state where you're located in Colorado, or if your station is near the border and you're advertising a lottery that is administered by a neighboring state legally, you can advertise that. Private lotteries are almost always not allowed if they are being conducted by a commercial organization, which would include the station. At least in Colorado, that's not allowed. Under federal law, some commercial organizations can conduct lotteries, but under Colorado law, they cannot, which means you cannot advertise them. But there are some lotteries that can be conducted by nonprofit entities, if they've been in existence for a certain amount of time and have a license from the Colorado Secretary of State to do this, then they can conduct some lotteries and could be advertised. The next thing in sort of the realm of gambling that we'll talk about briefly is sports gambling. Last year, actually, the Supreme Court issued a decision that overturned a federal law which had barred states from legalizing sports gambling, with the exception of Nevada and New Jersey, which have long been able to conduct sports gambling. That also restricted advertising for sports gambling, obviously. With that decision, the states are now able to regulate sports gambling as they wish on the state level. Colorado, to this point, has not authorized sports gambling, so you still cannot take advertisements for sports gambling. I have heard that there is some move to authorize some, at least to some degree, sports gambling in Colorado, but it's probably not going to get adopted until at least next year. There's also the possibility that the federal Congress could adopt legislation limiting sports betting. The Supreme Court decision last year, it turned on the fact that the existing law did not itself outlaw sports betting. It basically just said that the states could not authorize sports gambling. The Supreme Court said, no, you can't do that. If you want to prohibit it, you can, but you can't just tell the states that they can't do it. So, again, Congress probably has bigger priorities right now, but they could adopt some legislation limiting or putting certain parameters around what kind of sports betting there can be. If you're approached with a request to buy advertising, another thing to look at is, even if the state does allow this, that there may be restrictions in your existing agreements with sort of program providers that say you cannot put casino gambling, and various types of advertising in those programs. This really applies more broadly even than the gambling realm, but be careful with any of these program license agreements that may restrict the kind of advertising you can place during those programs. With that, I will turn it over from gambling to contests that may be conducted by a station, and obviously you would want to advertise them.
Thanks, Dan. As I mentioned earlier, when Dan was first getting started talking about gambling and lotteries, the law breaks down a regulated gambling or a lottery into three elements, which Dan mentioned earlier. There's prize. There's chance. You know, it's not a game that's based on your intellect, but just, you know, random chance. And then lastly, consideration. You have to pay to play. If you have all three of those, you have a lottery. And by definition, if you remove one of those three, you don't have a lottery. Then now it becomes a contest. And contests are far more permissible and less regulated than lotteries are. So as I mentioned, a contest is any arrangement in which there's a prize that's offered to the public, and that they only have two of those three ingredients. This is why many of you already know this, why you frequently hear that buzz phrase, no purchase necessary. You know, I get those, my daughters are always like, why do they put that in there? Well, because if there's no purchase necessary, you've now removed the pay to play element of the three-pronged test, and consequently, you don't have a lottery. You can promote contests on the air, as many of you know. Many stations use that quite effectively with their audience, especially if they trade out for goods and services and concert tickets, and T-shirts, coffee mugs. Those end up being great prizes to give out in contests. The requirements that the FCC has is that the contests that are conducted should not be misleading or false or otherwise deceptive. So what does that mean? How do you accomplish all of that? So, you know, an important element of this is that you fully and you precisely disclose all the terms, all the rules of that contest. And those would include the following. One, how to enter or participate in the contest. Two, what are the eligibility requirements? You know, so a lot of times you'll hear, you know, employees and family of the station are not eligible. I mean, you know, do you have to be over 18 years of age? Three, are there entry deadlines by which they have to get their forms or whatever or applications in? Are there prizes that are going to be awarded? When will the prizes be rewarded? The extent, the value, the type, and the nature of the prizes that are awarded. And then these are important. The time and the method by which winners will be selected, and whether there will be any tie-breaking procedures. You know, having those in there, having those written out, having those all those elements disclosed on your website at the station are critical and very, very important.
Right, I would just add that was an important change that the FCC adopted within the last couple of years, is you used to have to put all of those material terms on air in advertisements. You can now do that online. The FCC realized, you know, nobody's going to listen to a 30-second ad that just is, you know, running through all this legalese. You can now say, you know, you probably want to disclose some of the material terms, things like, you know, what the prizes are, how you can enter, but the rest of it you can make reference to a website that the terms will be disclosed on. You put them on the station website, and you just reference that website on air.
Right. Some stations also put them on if there's a form to fill out, if there's a ticket that you get. That sort of thing. And likewise, you can still, you know, make the announcements on the air. So getting that information out there is important. And then the next important thing is that you actually abide by those rules of the contest. You know, stick to the rules. Try to get no variation. Now, you may have a situation, this always comes up, where you have to, you know, vary from the rules. Something comes up, whatever, some prize that was going to be awarded no longer becomes available, what have you. And when that happens, we just urge, you know, our clients and stations to get the new information out there as quickly as possible. Make sure that if there are any changes that to those rules regarding the contest, get that information out and make the necessary announcements regarding the change as soon as possible, so that there can be no confusion on the part of your listeners and the contestants. So we're on the tail end here, and I guess I'm going to throw our final topic over to Dan here to cover sponsorship identification.
Yeah, sponsorship identification, this is just sort of a broad requirement that sort of plays into all of what we've talked about before, about things like truth in advertising, and that the listeners or viewers should not be deceived. There's a long body of FCC rulings and rules that say that also applies, that the audience deserves to know who is paying for the programming that's coming out. If there's a news story that the station is getting paid to broadcast, the audience deserves to know that. They should know who is paying for it, and that is not necessarily the station's own news opinion. It applies to all programming for which a station receives any consideration, and consideration is defined very broadly here. It does not necessarily have to be that someone is saying, I'll pay you $1,000 to air this program. It could just be that someone comes to you with a tape of a 30-minute program and says, here's some programming that you can air. Getting that programming for free is consideration. So you would have to disclose the source of that. This has come up, a number of years ago. This came up with sort of little segments that various advertisers were sending to stations to put into their news broadcasts that discussed a certain topic. They weren't paying the stations, but they were giving them the programming for free, and that needs to be disclosed.
Right.
You have to fully identify the sponsor who paid for the broadcast of the material or provided the material. Right. This is very similar, sort of a flavor of this is the long-standing rules on payola and plugola, which would be where, if a record label pays a DJ to broadcast, to put a certain song into heavy rotation or to play it at any point, that needs to be disclosed, that the station or the station and the DJ or anybody is receiving that consideration to broadcast, to play that record, to play that song, or to plug that song, to say really favorable things about a specific artist. Obviously, your DJs, if they really like an artist, can say that. But if they're receiving anything in return, that has to be disclosed.
This is a very common misconception on the part of many broadcasters, programmers I talk to out there, who they think, for example, that paying to put a record on the air is de facto a rule violation. That's not the rule violation. The rule violation is when that happens and you don't disclose it, when you don't identify the sponsor on the air. If you actually said on the air, we're playing this record because we received promotional consideration from XYZ record company to put it on the air, well, now you've engaged in sponsorship identification, and you're perfectly fine.
Yeah. And the other thing I'll add here, the last note here, is that sometimes it is very clear, particularly in advertising, that it is sponsored. If you have just a standard, Bud Light ad on your station, it's clear that they're the ones who are paying for that to be there. That does not need a further sponsorship identification. This really comes up when it is not absolutely clear from the programming itself that it is being paid for and who it's being paid for by. That is where you have to add a sponsorship identification to the advertisement.
Okay, well that's the extent of our webinar today. I don't know if we have any questions.
Yeah, there was one that came up real quick, which I'll just address very briefly. It referenced back to the marijuana advertising and whether there were restrictions on advertising on digital platforms. I don't know if we can get back to that slide, but it can be restricted. The DOJ, because it is an illegal product, if you're advertising it on a digital medium, in theory, the DOJ could come after you for that. It's unlikely that that would happen. The real hook that makes it far more dangerous for a broadcaster, as Frank was talking about earlier, is the fact that you are licensed by the FCC.
Right.
And if you have a purely digital medium and you're taking marijuana advertising, even if the DOJ comes after you, likely it would probably just be a fine. But if you have a broadcast license and you are convicted for advertising an illegal product, they can take away the license. And that is far more dangerous than it is for any other medium or advertise or distribution of communications that could take the ads.
Absolutely, that vulnerability there with that FCC license that makes all the difference in the world. Well, our hour is about up. I just want to thank everyone. Thank again the Colorado broadcasters and Justin Sasso. I want to let everyone know that copies of this presentation will be made available online and through the Colorado broadcasters. I also want to invite all of our listeners. Our firm has a YouTube page where we have copies of prior webinars on a wide variety of subjects, including EEO compliance, online public inspection files, political broadcasting, the list goes on. Feel free to visit us there. And otherwise, we'll see you at the next webinar, and enjoy the rest of your day. Take care.
Thank you.